started for you all. So hi, everyone. Welcome to the 2024 Mid-Year Labor Law Update. Today, we are so happy to have this sponsored by the Workforce Development Board of Ventura County. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. Before we get into today's content, I have just a couple details to go over with you. So as you see, your audio is muted for today's presentation, but there's going to be lots of opportunities to engage during the session. One of the ways you're probably going to want to engage is by asking questions. So if you can head over to the chat box along the bottom, you'll see, Q&A box, excuse me. Q&A box along the bottom, you'll see two bubbles. If a question ends up in the chat box, don't worry, we'll make sure that your questions get answered today. I'll be here the whole time making sure that Astrid gets all the questions for you. Handouts for this training, those were sent out in yesterday's reminder email. However, I'm also going to drop that into the chat shortly. So in a few minutes, you'll see a little file name pop up. If you click on the PDF name, then it'll download locally to your drive. If you have any questions, just shoot me a message in the chat box and I'll be happy to make sure that you get those the PDF handouts today. Last but not least, we have a survey. So because your feedback is so important to us, we ask that you complete a very short survey. It's 5 questions, takes really less than a minute to complete, but the feedback that you share with us, we then share with our partners over at Ventura County, and collectively we make sure that we are meeting and hopefully exceeding your expectations with resources and especially trainings like these. So if you could take the minute at the end, there will be a QR code on the screen. I'll also drop a hyperlink into the chat. And we hope that you take the minute to provide us with that feedback about today's training. And then, as I mentioned, today is sponsored by our partners over at Ventura County. And today we are so happy to have Roxana Gamboa, Business Solutions Specialist, to share more about the resources available to you.
Good morning, everyone, or good afternoon, everyone. My name is Roxana, and I am a Business Solutions Specialist. Thank you for the introduction, Anna. And you can, if you have not used our complimentary service HR hotline, please go ahead and do so. Take note. Your questions will be answered by an HR specialist who is an expert, and you can ask questions regarding hiring, firing, best practices, paid sick leave laws, wage and hour laws, employee handbook policies, HR compliance, accommodations in the workplace, and much more. The hotline hours are from 8 to 5, Monday through Friday, and it's a complimentary service that is provided to you by the Workforce Development Board of Ventura County. And then some of our services that we offer are also business solutions, such as sourcing and recruitment, job fairs, on-the-job training, subsidized internships, information about work opportunity tax credits, of course, the HR hotline, and all of this is provided at no cost towards our customers. And I will be providing the Business Solutions Service Guide on the chat, and I will also be including our contact information, my personal contact information. And then if you have any questions or any concerns, please feel free to reach out and we will address your questions, and someone from our team will get back to you.
All right, awesome. Thank you, Roxana and Rebecca
Thank you.
and your entire team behind the scenes for working so hard to help us produce events like this. Awesome. So now I have the privilege of, absolutely, thank you for joining us. So now I have the privilege of introducing our trainer today. We have Astrid Servin, who is one of our amazing HR directors, who if you do call into that hotline, maybe you have the pleasure of working with. So I know we have a lot to cover. So Astrid, it's all yours.
Thank you, Anna. Thank you, Roxana. And thank you, everyone, for being here, spending your lunch hour. Hopefully, you have your lunch with you today and can join me on this mid-year labor law update. We have quite a bit to cover. Before we get started, just a little bit more about us. We're California Employers Association. We're so happy to partner with the Workforce Development. I'm in a different county, but I've worked when I've had previous jobs with Workforce Development Boards and for separate counties. And you all are fantastic. You helped me out when I was in HR in the field. So I love partnering with you all, and I hope you all take take advantage of this great resource, which is that HR hotline. So call in. If you called in this morning, you probably had me because I was manning phones this morning. And we love to hear from you all. So continue to call us, ask questions in the chat and the Q&A here today. I'm happy to answer those as we go along and as time permits. So what we are is a consulting company, an HR consulting company. We also offer, in addition to that hotline that you get for free, we do offer membership. So if it's something more that you need in the HR field, if you need additional assistance and support beyond what the hotline provides, feel free to visit our website at employers.org and look and see at all the different things that we offer, such as templates and policies and handbook templates and trainings for supervisors, managers. We do both compliance training like this one, and then we do soft skills training as well. So it might be something that you or your company needs a little additional support on. You can consider membership. We do that on a monthly basis or on an annual basis. What we are not is a law firm. We are not employers, although we may have attorneys, but we don't offer legal advice. So everything that's presented today, I do have to have the disclaimer that the presentation should not be relied upon as legal advice. If something of legal significance comes up, we want you to have that opportunity to talk to your representative, to your lawyer in a confidential manner so that that is privileged and confidential, and they can guide you in the best direction. We are going to talk a lot about laws, some things that have come up, and both the state, which usually we only cover California because we're the trendsetters, right? But in this presentation, we'll also cover a federal law that has now crept up and also requires California to exceed what we already provide. So we'll talk about that new pregnant workers' rights under the federal law. But first, we'll start with wage and hour because employees have to be paid, right? They don't get paid, they don't work for free. So we have a lot of laws. The Labor Commissioner has us update those. And July was a huge month for a lot of increases in different localities. So we'll talk about those updates. We'll talk about the Workplace Violence Prevention Plan, which may be the reason why you're here. Lots of updates. Those went into effect July 1st, as well as the heat illness, which we have new laws that just went into effect this week. So we're very current. Our content is very current as of today, and then lots more. So let's get started on that here, and I'm just going to check and make sure there isn't anything. Okay, all the chat stuff is from you, Anna. That's good. So let's get started on wage and hour because there were some increases to local minimum wage, but before we do that, we'll discuss what the current minimum wage is for this state. So that went into effect in January. And for all employers, if you are, and especially for Ventura, I don't think you have too many counties or cities within your municipality, within your county that differ. So the state minimum wage does remain at 16 an hour right now as we sit in July. And then for exempt or salary employees, for them to be exempt from any kind of overtime, meal period, time card obligations, they do need to be making a minimum of $66,560. Remember that number continues to creep up. Every January, we get an increase to minimum wage. We get an increase to exempt salary. So some employers are starting to see the timeline and look at the future to see, gosh, I have to keep continuing to increase my exempt employees. Is this maybe a time where I now look at transitioning them to an hourly position instead? And if that's you, we do have a fact sheet, a little cheat sheet, if you will, of tips of how you transition an exempt employee, because there's a few things you have to consider, and especially the way you communicate that to your employee, bringing them from an exempt position to an hourly. The other thing I like to remind employers about in this section is to be exempt means that your employees are following both, are meeting the criteria for both the salary, which is the 66,560, but also the duties test, that they actually are eligible to be exempt under the duties test. And there's some criteria that you have to meet. So if you are in need of that, please visit our website under employers.org, and we have a fact sheet on the various different exemptions that you have to meet for that. So somebody asks, salary exemption is based on state minimum wage or regional? Great question. And there's only one exception to that, but it is based on the state minimum wage. So even if you have an employee in LA or San Francisco whose hourly minimum wage is higher, the exempt salary for that location continues to be the 66,560, with one exception, and we'll talk about that, and that's to the fast food industry. That's going to be different for them. But our local minimum wages, we have over 40 of them, of local ordinances that can apply. And typically, when the minimum wage is higher in a local municipality, then the sick leave usually follows it. So there's a lot of times where you'll follow the minimum wage for that county or that city, and you'll have to look and see whether they have a sick leave also, dictating additional sick leave in addition to what California already provides, which is the 40 hours in a year. The sick leave might be higher in certain areas. Same thing with predictive scheduling, which is gaining a lot more popularity. We have certain industries in LA and in San Francisco that require it already. And San Francisco, LA usually are the trendsetters here, and then the rest of the state follows. So we do see that predictive scheduling coming up a little bit more, maybe not in the near future, but in the far out future. It's something that's probably going to apply to the rest of us. And the predictive scheduling looks like this. It's especially for employers who post weekly schedules. So they post it, maybe it's a retail or a store where they post a weekly schedule. An employee has to go look to see what they're working. Well, the predictive scheduling is saying you have to, as an employer, have so many days of notification when you post that. If you make a change to that schedule, you have to give them so much notice. So things like that will apply with predictive scheduling. That already applies in certain industries, in certain areas, but maybe look towards that in the future for the rest of us. Local minimum wage is based on where the employee is physically working. So this came true a lot during COVID, where people went to work from home and there was hybrid situations and you had people working everywhere. Now you have to pay attention to that, right? Because we have to know where the employee is physically working. That's where the laws apply. Even if they're working out of state, the laws of where they are working are the laws that we have to follow for that employee. So July 1st showed a lot of local increases here in both Northern and Southern California. So if you have employees working in these areas, follow this bit.ly here, this website, if you can, copy and paste, because we also post the sick leave ordinances. So if there's a sick leave ordinance in this area, you're going to get it all. So the July 1st fact sheet has been updated with the increases of what they specifically are. If you're in need of that, go there and you'll be able to have them. And thank you, Anna. She put that on the chat there, so you can just click on it. So here's a question here, kind of transitioning, but still in the area of wage and hour. Before our employees start their day, we have a security screen process. Employees must scan their badges and go through a bag check and metal detector. The process is about 5 to 10 minutes each day, as a line often forms. Employees then clock in to start. Is this okay? Uh-oh, probably not. So we have a new case in this year. The 2024 case is Huerta versus CSI Electrical Contractors. And this is a reminder that employees should not be engaging in pre and post shift work that's off the clock. It actually has to get paid. Let's look at this case a little bit closer to see if it applies, because you may not have a security checkpoint, but you might have an area where you have one time clock and a lot of different employees trying to clock in. Is it or is it not controlled time? So in this case, this is the way the court ruled here. In Huerta, the employer had a security checkpoint to enter and to exit the work site. The guards would scan each employee's badge, and sometimes they would even check that vehicle to see, just for security purposes. And so then a line would form. It would back up, and it would take this employee 10, sometimes 30 minutes to actually go through the checkpoint, and they had to account for that when they're going to be late or not to be on time. They accounted for this 10 to 30-minute delay. And so the company was like, well, that's off the clock work. You're coming in, it's just kind of like commute time, right? You're coming in and it's just the cost of doing business here where you're going through that checkpoint. But the California Supreme Court found that the time was compensable as hours worked, because the employer requires specific and supervised tasks during the checkpoint process. So because we control, there was no other way to get into the facility, and they had to scan and be subject to additional security checks. That's controlled time. So when the employer is controlling how you get in and what you're doing, then that is what they determined was compensable time. So that's the reason why it went in the employee's favor in this case. So if you have something similar to this where it requires you to check bags, something like this, then be considerate of the time it takes them to do that, and possibly pay them a little bit more. So some tips here: do not permit pre and post shift work off the clock. And sometimes it looks like security screens like the one we described. Sometimes it's gearing up machines or logging into computers, and you tell the employee you got to log onto the computer to clock in, for example, or donning and doffing protective gear, answering emails or discussing work tasks for the day, locking up and setting the alarm. As you know, Starbucks got in trouble for that, where they're setting the alarm and locking up, and it takes some time to do that, is what the employees argue, and they want to be compensated for that. Cleaning up at the end of the day, this could create that risk for a possible wage and hour claim. So if these things are happening, find a way around it. Find a way where you're paying them for that time. Sometimes paying them those extra 5 minutes to do this work is going to prevent a wage and hour claim. So there were a few other issues with this Huerta case, some employer and some pro employee. So the drive time was one that actually went in the employer's favor, because after the security check, the employee had to drive another 15 minutes. This must have been a huge area where the employee had to first check in with security and then still drive another 15 minutes before they reached the parking lot. Employee said, I should be compensated for all that time, from the security to the time, because it's 15 minutes. And we're required, you controlled how fast I drove during that time, because there were speed limits that I had to comply with, and so I feel like that time is controlled. But the court said, no, that's part of your normal commute time. That is not controlled time. The security check, yes, and waiting for the security check, but once you're past that and just to get to the parking lot, that's not controlled. So in a way, this was a good thing for the employer, that they didn't have to pay that extra 15 minutes, and so this was not compensable. But the other thing that didn't go in the employer's favor is this on-duty meal break. So based on the agreement, this was a union environment. They had a collective bargaining agreement between the employer and the union. And in that collective bargaining agreement, the employee and the company agreed that they had to remain on the premises and that their meal periods were not paid. And we all know that's a violation. You have to, if you remain on the premises, you have to pay them for the meal period. But in this CBA, it was agreed that they wouldn't for some reason. Well, the court found that the employees must be paid for on-duty meal periods, even if it was under the CBA. So some things to learn from here is, if you have, and I know I've had an employer who said, well, we all agreed we wouldn't do sick time. We would just increase vacation. So we're not doing sick time. It's in the collective bargaining agreement. It was voted on. We liked it. It was good. Well, the state would probably find that inappropriate as well, because you could put that in and everyone agreed to it under the CBA, but especially in this court case, it's a violation of California law. So even if you all agreed to it, it's not permissible. So remember that on-duty meal periods are rarely permitted. We really should be giving our employees time off. And if there's a case where we cannot give them the time off to go take and break for their meal, then we really need to prove that. So it's only when the nature of the work prevents an employee from taking a meal break. And then even then, the employee has to voluntarily agree in writing that they're going to remain on the premises and be paid for that break. So you have to allow the employees, for the most part, to leave the premises for both their meals and their rest breaks, by the way. It used to be we could control the rest breaks because we pay them for the rest break. Law says no more. We have to allow them to also be in and out for rest. If they're able to go to Starbucks and back in 10 minutes, we have to allow it. If a meal or rest break is insufficient, we didn't give them the full 10 minutes or the full 30 minutes, then a premium pay is owed. And I hope you all know that. That's nothing new. We owe them an hour worth of pay at the regular rate of pay. And it does need to be reflected in that wage statement. And that is fairly new. That came into effect last year, I believe, where you have to have a separate line item that actually says premium pay due to that insufficient meal or rest break. And remember that premium pay is in addition to the pay time for time spent during their meal break. So if in fact they are staying on the premises, you pay them for the meal period, and because they weren't able to take their lawful break by the 5th hour, you're also paying them a premium pay on top of that. Okay. Let's get out of the wage and hour land, and if you have questions, feel free to put them in and I'll try and answer as we can. But let's get out of the wage and hour land, because we have a lot of health and safety stuff to talk about, because this has also come into effect and is effective now in July, and we're in it a couple of weeks now. So what I'm talking about first is the Workplace Violence Prevention Plan, the WVPP. So back, just some kind of history here. Back in 1993, California became the first state to require healthcare facilities to have a violence prevention plan. So they were getting, this was aimed at protecting healthcare workers against and the public as it relates to violence. And so they also did the same for the corrections department and the jails and rehab centers, but nothing for the general public. And so for years, Cal OSHA said, we know, and we saw it on the news, there's so many violent acts, we need to have something. But they never did. I mean, this is since 1993 that they've been trying to implement something for the general industry. So the legislators stepped in, and that was due to an actual incident that occurred in the Bay Area, I think it was Oakland area, where a congressman said enough is enough, and they stopped. They said we need to enact something. So Senate Bill 553 is what was implemented, and Cal OSHA is now going to be over the Senate bill. They're actually the ones guiding it. They're authorized to fine and control this plan. They do have until December 31st, 2026 to make any amendments and changes and to formally adopt it. But the Senate bill is in effect, so you do need to comply with it. And what it does is it's a requirement to establish, implement, and maintain a written workplace violence prevention plan by July 1st. So this is going to include employee engagement, and you must train your employees. There's very limited exceptions, which I'll talk about next. But just remember, if you're panicking right now and you haven't done it, it's okay. We have a lot of information to guide you and help you through it. Know that a lot of employers are in the same boat because July 1st came fast, and a lot of people are in the process. Some have done it and are in compliance. Others are still kind of struggling to get through. So the exceptions, if you feel you're an exception to this law, the Senate Bill 553, then you may fit under one of these. Either you're completely 100% remote, so teleworking employees, nobody comes into the office ever, not even for annual meetings, then you're okay, you're exempt. Then also places with fewer than 10 employees at any given time. So if in the future you have 11 or 12, then you wouldn't be exempt. Or if you had, as of July 1st, 11 employees, you wouldn't be exempt. So this is at any given time, you have to have fewer than 10, and you're not accessible to the public, and you have an injury illness prevention plan, then you're exempt. So again, like a coffee shop that only has 5 employees, this would not fly because they're accessible to the public, so they would have to comply. So this is only for those offices that do not see the public and have less than 10, then you would be okay so long as you have that IIPP. As a reminder, we're all required to have an IIPP, which is an injury illness prevention plan, and that's a plan for our safety in our workplace. We're all required to have that written plan. Cal OSHA provides that template as well. So the only other exceptions are those that already have they're covered under a different standard. Healthcare, Department of Correction, and law enforcement, they already have one. So everybody else has to comply. So what are some examples of workplace violence? So it would be a physical attack with or without a weapon. So think of employees fighting in the workplace, threat of physical force. So think of threats of employees engaging in threatening each other to fight each other. That would be an example. Sexual assault or unwanted verbal or physical sexual conduct. So now you'll have to consider the employee sexual harassment complaints, which you're required to investigate. You'll also have to you kind of have to do a dual. You're required to investigate under the Department of Fair Employment Housing for any kind of sexual harassment, and then you'll also be required to your own requirements under the Workplace Violence Prevention Plan. If you have an animal attack, such as I know we have some members who are vets, dog boarding, or even if you have employees out in the field and they get bit by a dog or something, that would be included. And then there's this thing called other. By 2026, Cal OSHA does have to define what other means. If you feel that it fits under this category, and there are a little bit more detailed definitions under each one and examples of what it could be under each one of these as well. So if you need more detailed in deciding whether that violent act fits or not, more than likely, if you're thinking, does it fit? It probably does, but you can look into the Senate bill a little bit further for more explanations. So as an employer, what are your key requirements here? Your requirements is to create a written plan. And thankfully, Cal OSHA has provided that template for us. So if you go to Cal OSHA's website or if you go to employers.org, we have the link for that written plan. You can download it and start personalizing, very similar to the COVID prevention plan back a few years ago when we had we still have to do that. It's still a requirement to have a COVID prevention plan, but it's changed and morphed a lot. So Cal OSHA did provide us with this WVPP written plan. So you'll have to go in there, and there's a lot of red sections. Those red sections are suggestions on what you can include in your plan. They're not mandatory. I think we get that question a lot, like, do I have to do all of this? You do not have to do all of that. Those are suggestions from Cal OSHA, things you can implement, but not necessarily anything that you actually have to do. You also have to solicit employee and union involvement, and that's a big one because you cannot have a completed written plan without soliciting your employees. So if you're a member of CEA, we have those questions for you already that you can provide for your employees. And even if you're not a CEA member, we do provide all this support. The written plan is free from Cal OSHA, but what is not free are the additional requirements. So the feedback from your employees, you have to conduct an annual employee training. The training is very specific on what you have to train on. And the trainer has to be someone who was involved in your written plan, or at least be available in that meeting when you train all of your employees on, okay, I'm familiar with this written plan and this is what it says. CEA has made a PowerPoint template that as a member you can get at a discounted rate, but you can also get if you're not a member, and you can just click on that. It's a 30 plus slide deck, and it shows you there, it actually just, it's already done, all the training requirements that you have to do. What you're going to personalize are the things like your employee feedback. What did they say? When you do your periodic inspections and hazard corrections and you have your safety meetings, it'll have a place for you to put on there and personalize it. So I highly recommend something like that if you haven't done it, because it can be overwhelming. The other thing you'll have to do is investigate any kind of workplace violence incident so that you can keep record of what you did and also log it in your violent incident log. So again, those forms are available if you'd like through our toolkit. We have that package available in our store. If you go to employers.org and go to store, that information is there. But I would recommend you getting started on this if you haven't already, because we are past due on that deadline. So try and see if you can get at least solicit that employee feedback. It's something you can do easy, however you communicate with your employees, whether it be an email, a text. If all your employees, another question we get often is, well, what if they don't respond? I've already tried, they haven't replied. Try a little harder if you can and try to solicit that employee feedback. You don't need 100% participation, but we need to show that we've attempted to get that feedback from employees and that we've waited for their response. Maybe we attempted twice. Maybe we meet with them and interview them then because they're not responding. And you don't need 100% participation. You just need certain ones that respond, and then you can go with that information, that feedback that's being given to you. Okay, so moving on away from the workplace violence prevention plan, and again, you could always give us a call at that free 800 number to ask for clarity on some of those things because it can get overwhelming. Well, this is hot off the presses. Just on Tuesday, July 23rd, this new standard went into effect, which is the Indoor Heat Illness Prevention Plan. So just again, some history. On June 20th, Cal OSHA voted to adopt an indoor heat illness standard that applies to most indoor work areas when the temperatures reach or exceed 82 degrees while employees are present. It's mainly aimed at manufacturing warehouses, restaurant kitchens, things like that do not have a full AC system. It's aimed at those locations. But this standard was, up in the air forever. When was it going to go into effect? And then we did hear notice on Tuesday that it went into effect as of July 23rd. So this is now something that the law of the land. So remember our outdoor places of employment. If you have outdoor employees working sales forces, that kind of thing outdoors, we already had that requirement to maintain a written heat illness prevention plan. So this is all going forward for any indoor places, and what it applies to, what you have to do. The requirements are to include water, a cool down area. So it has to have like a room or a certain area where employees can cool down. It doesn't mean we're going to cool down the entire warehouse to make it less than 82 degrees. It means we're going to have a section of the building that is a cool down area designated as that. We're going to have a written plan. We're going to train our employees and our supervisors and have record of that. And then we're going to have an emergency response procedure. So this is all, again, a template provided by Cal OSHA that you're going to personalize, and you're going to come up with your policy and your location as to how we're going to direct it. What are we telling our supervisors and employees to do? Are we posting things to remind them to take a break and go to the cool down area as they see fit when the temperature raises over 82? Cal OSHA has actually a wonderful Q&A session that they can that answers a lot of your questions if you have kind of like the more detailed information about this. So additional high heat requirements are there if the temperature exceeds 87 degrees, or when someone's wearing restrictive clothes and they're at 82 degrees. So there's a little bit more to do if you're in these industries. I highly recommend going to that Q&A at Cal OSHA. We have a blog about it right now. If you go to employers.org and click on blog, free articles there that speaks to the heat illness specifically, and it have a link to the Cal OSHA website and also to the FAQs. So thank you, Anna. You're already posting all that stuff. I appreciate that. So remember that main thing is that written plan, similar to the workplace violence prevention plan. Train your employees and have a plan in place as to what measures you're going to have and what areas you're going to have and how are you going to communicate that to the employees. The best thing is to train your supervisors, because a lot of times employees are going to say, I need a break, and it will be an extra break in order to go cool down in that cool down area. Your employers, your supervisors need to know that that is allowed, that that is the law, and not say no to those employees. How long they're going to take, is it a 5-minute break? And it typically is a 5-minute break or so. But again, go into the Q&A so that that provides a few more details on how you're going to come up with your plan. What are you going to say? Okay, I'm just checking to see any questions. Okay, good. All right, so let's go on to the employee rights and protections, because we do have some federal laws that are going into effect now, and so that already are in effect. But it's a little bit unusual because California tends to be a trendsetter, and we have more protections and leave of absence more than any other state, really. And so even when it comes to pregnant workers. But let's talk about the Pregnant Workers Fairness Act. That's just one more thing we all have to worry about when an employee is pregnant. The Federal Pregnant Workers Fairness Act passed in June. The EEOC regulation, June of last year, but the regulation became effective this year, June 18th, 2024. And it is modeled after the Americans with Disabilities Act, which applies to employers with 15 or more employees. But it is more expansive than the ADA, because now we're going to be required to accommodate for limitations related to pregnancy, childbirth, or related conditions. So things like morning sickness, migraines, need to attend prenatal appointments are covered under this plan, which in the ADA was not covered before. So this is a little bit more expansive as far as the federal law goes. So how does that relate to California? Because California, our protections here, we already are required, and if you're an employer with 5 or more employees, we have to reasonably accommodate disabled or affected by pregnancy. So we're already doing this. If they have morning sickness and they have a medical note, we're already accommodating that. And we also provide 17.3 weeks max of pregnancy disability leave. It's usually not that much. It's usually a lot less than that, but it can go as high as that, so long as it's certified by a healthcare provider. And then we have our protections under the pregnancy disability leave that says no harassment, no discrimination, no retaliation against a pregnant employee. So that's our California. So how does this new federal law impact California employers? What's the change, if anything, for us in California? Well, there are some changes. For instance, when the EEOC regulation is more protective. So for example, for those employers with 15 or more employees, you have to temporarily suspend any essential job function, which is not something that we did before. So the employee could perform the functions in the near future, and the inability to perform the essential functions can be reasonably accommodated. So that's the inability is temporary. We can temporarily do that. And then provide certain predictable assessments. So predictable assessments means We allow them to carry additional water. We give them possibly longer breaks if needed so that they can eat or use the restroom, maybe additional restroom break. Sit when standing is required, and then stand when sitting is also required. So these predictable assessments is usually judgment calls, but they are almost always something that's not going to create an undue hardship. If an employee asks, can I sit? Is that really creating an undue hardship for the employer? If likely not, then you should accommodate them. So that's what that is. And there's no request for medical certification in certain instances. So again, those judgment calls, if an employee is saying, can I sit instead of stand, or the other way around, can I stand instead of sitting? We're not going to require them to provide a medical note for that if it seems reasonable. These are the things that are these predictable assessments. If it's something more that can possibly create an undue hardship, or a request that's very difficult to accommodate, yes, we can, but then I would consider them asking for a medical note. But for the most part, for this law, we're not going to require that medical certification, which is more protective than California would require. So, our employee Erica is pregnant. She presented a doctor's note certifying that she can no longer lift for the remainder of her pregnancy. And lifting is an essential function of her job. So, how do we respond to that? So, we're saying, look, this is part of your job. It doesn't sound like you can do it then. So, how do we respond? Well, according to the EEOC, if a pregnant employer is temporarily unable to perform one or more essential functions of their job, you can offer light duty, so reassign those, change that work assignment so that now they do less, or for up to 40 weeks, unless the employer again can demonstrate that undue hardship. So sometimes that is a little bit harder burden to prove. Um, does this also cover employees requesting to work from home? Possibly. So if the accommodation is to work from home, I would probably say that's a harder burden, and that I don't know that that would meet the criteria of a predictable assessment. I would say that probably would dictate you requesting a medical note. It's a fine line. If it's something that every employer is different. If it's something that is easy, you allow employees to work hybrid, I would say, why are you going to ask for medical certification? It's a justifiable thing. You can allow it. If you don't allow this at all, and it is a huge change to your workforce, then you may want to consider that medical certification, as because it does not fall under those predictable assessment. So it's a judgment call. You can give us a call. We can kind of speak to it if that was to happen. Um, we can help you kind of with that assessment. We can't make any legal calls for you, but we can maybe help you with that, with the details of that information. So instead of just offering a leave of absence as may be required, because that's what we tend to do. Employers are like, well, if you can't do your essential job functions, then I'm putting you on leave. You can't work here anymore. That's a very common response from employers. And this is aimed at trying to combat that. We don't want employers, so the law doesn't want employers to just say, well, then you're going on a leave of absence. They want you to really try to accommodate this, similar to a workers' comp claim, where we really try to have the employee stay at work and find them something to do. This is what the requirement is now. It's a temporary reassignment, and if it doesn't create an undue hardship, see if you can please accommodate this employee instead of putting them on a leave. Now, as a last resort, you can do that as a leave. So there are circumstances where, you may feel like it is an undue hardship. There may be a difference of opinion whether that's an undue hardship, and that's when I would go to your attorney and talk to your attorney about, this is how we're feeling about this. We think or half of us feel like it's an undue hardship, the other half feel like doesn't meet that criteria. That's where your legal counsel will help you make that determination whether or not that's something, how you should follow your rule. There's some very helpful articles there from the EEOC when they released this, and this went into effect in June. They released a lot of guidance regarding this and examples. So if you need additional information on that, just go to the EEOC's website on this new rule. A note on lactation, we want to kind of review this as well. California has extensive protections regarding lactation accommodations. If you're a member, you have our sample lactation notice and request forms already. The federal protection is that PUMP Act that went into place in 2022. And it's basically saying, the EEOC is saying, and California already has a very similar protection, but a lactation accommodation includes permitting the employee to nurse the baby during work hours, where the child is in close proximity. So you're thinking of remote workers, break to visit a nearby daycare facility, for example. The EEOC is saying you have to permit that. So California already had the lactation where you have to allow breaks for and to express milk. Reasonable time to do that is always has been in effect. What the EEOC is saying, and just as a reminder from the Pump Act, is that if the baby is in close proximity, you have to allow that during work hours as well. And just remember all the notices that go with that, because we do have to notify employees at new hire of this policy and of this law. Okay, moving on to the EEOC's harassment. So some other federal rules that came into effect after nearly 25 years in April, the EEOC updated its harassment guidance with a lot of examples and clarifications, such as harassment can include intrusive questions about sexual orientation, gender identity, transition, or intimate body parts. And then harassment of LGBTQ workers can include denial of access to bathrooms consistent with gender identity. So all these things have been added because 25 years is a long time. We've made a lot of adjustments, especially in California. The EEOC was catching up and they actually became very specific and gave a lot of specific examples. So harassment can be based on pregnancy, childbirth, or any kind of related medical conditions, and they went into more detail regarding those medical conditions as well. And then harassment can occur in remote work environments. I believe in California we were already working under this guidance anyway, because our Department of Fair Employment Housing has, and our FEHA, Fair Employment Housing Act, has a lot of these protections already. But just know that the EEOC did expand their harassment guidance after nearly 25 years, and they include a lot of those examples. And when they give us those specific examples, we kind of learn from them. So you may want to see that published draft of what they came up with, just to educate yourself. If you are a trainer in harassment and prevention training and you need to know this, or if you investigate these claims for your location, you should be aware of some of this guidance so that you can be a better trainer, better investigator. Anything else I want to say about this? Let me just take a look here. All right. Okay, artificial intelligence. We did want to, I just came back from a big conference, and the big topic right now is artificial intelligence and how that is such a current topic, such a current thing that every employer is using in one way or another. So we just wanted to shed some light here on an EEOC case that had it. It's Mobley versus Workday. The EEOC argues that an AI company that provide resume screening services may be directly liable for discrimination. So I think we're getting better about this, but when AI first came out and companies were using them for things like resume screening and all that, it became problematic. So the Civil Rights Department, which is California's CRD, the California's equivalent to the EEOC, also has proposed regulations to increase AI enforcement and limit employer uses. And they're really aimed at discrimination. They're feeling like these AI machines, these AI software things are aimed at just looking for certain things that then may disqualify certain applicants who may be qualified. So just a reminder to employers to proceed with caution when using AI. Company leaders should monitor those developments and consider forming possibly an AI committee. We want to make sure we're not unintentionally discriminating, and it has been very unintentional from what I've seen, but it definitely is happening. So I think they're getting a crackdown. I know Indeed is huge on it right now and trying to make sure that their AI is not filtering out people who are very well qualified and discriminating unintentionally. So consider a policy and training for staff on permitted uses of AI, even things like, creating policy using ChatGPT. You're putting proprietary information into this software system, into out there on the web. So we want to make sure that do we have a policy in place of how you use it responsibly, and when you do not put our proprietary information on there. If you're using things to translate, for example, services, are we putting all our proprietary things there that are out there and for someone else to keep? So what do we want? Who do we want doing this stuff, so that we are aware of what's out there and how we're using it responsibly? We do have a sample AI policy available for CEA members. If you go to HR forums, you'll see that template there that you can use on just how to use AI in the workplace. There is a healthcare minimum wage if you're in the healthcare industry. The goal is for healthcare workers to earn $25 an hour and then have initial increases. This has been delayed multiple times, and we are always staying on top of it. We're HR nerds here at CEA, and we like kind of just staying on top of all the things. So we do regularly check for this. Initial wages are ranging from 18 to 23 an hour by either October 15th or January 1st based on the budget, California's budget. So healthcare workers, if you're out there, be on the lookout. We have updated our blog. So if you go to blog, we have a recent article, not too long ago anyway, and we keep updating it. So if this is to pass faster, and it's either going to be October 15th or January 1, we'll let our members know about that. And actually, you can just subscribe to our newsletter and we will let you know as well without being a member. But to qualify as exempt, employees have to be paid at least 1.5 times the healthcare minimum wage or 2 times the California's minimum wage, whichever is greater. So just know that this healthcare minimum wage, if you're in that industry, is still kind of up in the air, and we're still waiting on some things before they're finalized. But it's going to apply to virtually every medical employer, including but not limited to facilities or work sites that are in the healthcare facility system, licensed hospitals, clinics, physician groups, all that stuff. So if you're in this area, it's probably going to apply to you. So just be aware. We have this right to disconnect. This is a proposed bill, has not been passed, but they have this bill out there, AB 2751, and it would have applied to public and private employers and required employers to define what non-working hours are in a written agreement. And then the employers are enabled to contact those employees during those non-working hours, except for scheduling and emergencies. So this right to disconnect is aimed at, again, like once you're off the clock, you are off the clock. You shouldn't be working or thinking about work. And so we're going to put it in writing, and it comes from European countries have been doing this. So it's modeled after that. But it would give employees the right to ignore communication during non-work hours and even file complaints with the Labor Commission for a pattern of violation, which could result in penalties for the employer. It would not apply to employees under a collective bargaining agreement. They have actually said that the collective bargaining agreement can be different than the law. But stay tuned and follow our blog for updates, because we're a little worried about this one and how this is going to come into play and how many wage claims can be filed when, if and when this passes. But it's going to be aimed at, again, this right to disconnect for employees. And emergency has been defined, at least the way it is right now, to mean an unforeseen situation that threatens an employee, customer, or the public, or disrupts or shuts down operations, or causes physical or environmental damage. So you'd be able to interrupt them if it was something like that. So just so you know, it's kind of out there, it's been proposed. So as we wind down here, what is next for California employers? Well, we want to ensure you're paying employees properly and capturing all hours worked. Just as a reminder, if you have hourly employees, we have to have time cards. I was telling everyone I manned the hotline calls this morning. I don't know if I saw one from Ventura, but we had a couple of employers who don't have time cards for their hourly employees. They're not tracking their time, and that's a requirement. If we're up against an employee at a wage hearing, how are you going to prove that they were paid for the hours they worked? So just as a refresher, as a reminder, please have a time card that's approved by the employee, that the employee can adjust or amend if there's any discrepancy, that we're capturing the meal break by the fifth hour, and this is for your hourly employees. But to make sure that you are working towards that. And then make sure you're in compliance with your workplace violence prevention requirements, SB 553. Again, if you haven't gotten started, we have free resources on our website, and our template is there. The template from CalOSHA is there. Get started now. It can be as easy as the end of today, you send out that survey to employees. You can blast an email to them, you can send out a monkey survey to them, and just get the ball rolling with that workplace violence prevention plan. It is a bear. It is a lot to cover, so you want to make sure that you are taking the time to get the feedback, and then providing what are the what are we going to do? What are the measures we're going to do? Are we going to have a code word? Are we going to tell everybody code yellow, and that means evacuate the building? So those are the things that you're going to discuss in your meetings. You're inviting your employees to participate in that, and that's what you're going to put up in the plan, and that's what you're going to train your employees on. So very important information on that SB 553 that you'll be required to do. And then consider policy and training updates regarding those worker accommodations, because everything we talked about with the EEOC has to be reflected in your handbook. So make sure that your handbook is being updated with the new requirements. 2024 probably had the biggest year of changes. So if you don't have a handbook done in 2024, I'd highly recommend that because there were a lot of changes to the laws in the beginning of the year and even now mid-year. So it's a good time to review your handbook and ensure you're getting those updates. And then stay tuned to ongoing developments by following our blog. We have a blog that's free, and you could go there, employers.org, and we write frequent articles, weekly ones, and it's usually on the hot topics. So what's going on? So right now you're going to find the heat illness prevention plan, you're going to find the workplace violence prevention plan, and all the increases in July 1st covered on there. So our goal is to always keep you updated on the most current information so that you don't fall behind, because it's a lot to take care of in California. There's always something new. As of this week, there was something new. So we want to make sure that we stay tuned for that and report it out to you and communicate it out to you. So just as a reminder, we have that complimentary HR hotline for employers. You can give us a call. Oh, I think this is the wrong one here, but I think we provided you that link there for you all. But please give us a call if you do require additional assistance. We're more than happy. Your calls are up to 15 minutes with an HR consultant, and we can review certain things for you. In addition, we do offer that membership. So if it's something you need that's additional support, please consider the different options that we have. And with each option, you get a little bit more. So it depends on what your needs are at your company, how much HR support you actually do need. And then we also offer monthly membership as well. We want to just spend those last couple minutes talking about our HR Assist program. If you're an employer who needs us to come on site to help you with an investigation, provide training for your employees, and it's an additional, you something that you actually want. Maybe your HR person's going on a pregnancy disability leave and they're going to be gone, and so you need someone to cover. These are the kinds of things that we do. We have plans that are 4 hours a month, 16 hours a month, or more. So depending on what your needs are, it's a discounted rate if you go through the HR Assist plan. So there's a flyer there for you if you'd like to download and take a look at that program. And I will throw it back. We ended a little bit early. We have time for questions. If anybody dares to ask any questions in the Q&A there or in the chat, please let us know. If not, I'll throw it back to you, Anna.
You must have done just the most remarkable job, because yeah, we only had a few questions. So I'm really really happy to see that, but we do have just a couple more minutes. So if there's anything else that pops up, go ahead and throw that in the chat while you have access to Astrid. This is priceless time right now. But I do want to thank the team at Ventura County. So Roxana, Rebecca, thank you for joining us today. I know Cynthia and Colleen are also behind the scenes. So thank you all for working as a team to bring everyone here live today. Thank you all for showing up live on your lunch hour. I do want to direct your attention to the chat. There is the next free training coming up on August 28th. It's a very popular one. It's top 10 ways to stay out of California court. This is a really good training, also very compliance heavy. Yeah, it's a really good training. So really encourage you to take advantage of being able to register for free to get that content. The training code.
I have to say, Anna, that's probably my favorite training to train on, and because it's the top 10 ways. It covers everything to keep you in compliance. So I would stay tuned for that one. It's one of my favorites, probably the most requested one out there.
There you go. From the trainer's mouth herself.
It covers a little bit of this, a little bit of that. So everything from leave of absence to wage and hour, everything.
There you go. There you go. Cool. So training codes again: HRCI code 671975, SHRM code 24-SCNSS. CEAinfo@employers.org. If for any reason you have any trouble redeeming those codes, just shoot us a message and we'll make sure that you get credit for sharing your time with us today. And then I did want to encourage you one more time to share your feedback with us. Again, it's 5 questions Many of them are multiple choice. They're super simple, but the feedback that you share with us, we then share with our partners at Ventura, and we just want to make sure that we are hopefully exceeding your expectations with trainings like this and our entire suite of resources available to you. So if you could take the time, that would be really helpful. So I guess with that, thank you again, Astrid, for sharing your time and your expertise with us. Thank you, Ventura, for sponsoring, and thank you all for joining us live. We hope to see you August 28th. Cheers.
Thank you.
Thank you.